May please, Lordship.
If your Lordship permits me, my lord, I may go through the record of item number 40, my lord. There is a series.
Well, in respect of item number 31, I have a prayer for taking up the matter at 2. This is a review petition. If kindly take it up at 2.
May it please, Your Lordship, I beg your indulgence, Your Lordship, and taking for examination item number 22, Your Lordship. I need to present the admission for my son, Your Lordship. Item 22, after 1 week, Your Lordship. Lordship, leave.
Make this a Lordship. May I pray for listing of a motion matter tomorrow, my lord?
Hello.
Just item 29, Lordship. Better we will taken up before writing the court, if possible, the petition. Police is contemplating to arrest the petitioner. If court of life. Motion matter first step.
May it please the Lordship, Lordship. Item number 3, Lordship. Kindly adjourn the matter for the day, Lordship. Lordship.
May I please, Lordship? I beg to mention item number 13, Lordship. Engaged counsel, leading counsel, BK is suffering from illness, Lordship. The matter may be. Lordship, there is the interim, Lordship.
Just wait.
Item number
13.
Item number, this may be adjourned for 1 week only. 5. My lord. In the meantime, my lord, I maybe to find clear court record. My.
May I please, Lordship? Lordship, I beg to mention item number 26. Lordship, my senior is out of station. Lordship, may kindly adjourn the matter for today only.
Yes, next.
Object. May I please, Your Lordship? Lordship, I beg to mention item number 10. Lordship, so my submission is English counsel's mother is in the hospital, Lordship.
Please wait. You renew the prayer when the matter is called. Without looking at the records, you are not adjourning 2019 matters.
Oh, bless you.
Item 1 for motion.
May I please? My lord, impugning order is at page 52, my lord, annexure 15, my lord. Order dated, my lord, 24/6/19. Page 52, my lord, annexure 15. Relevant person will find at page 53, my lord, critical analysis of the reference. My lord. Not exhibit H, my lord, at page, my lord, 14, my lord. Annexure 1 of my petition, my lord.
There is a written statement.
My lord, written statement at page, my lord, at page, my lord, 39.
Then I said 13 million. There is no pleading with regard to your land in the written statement.
My lord. Well, it has been exhibited, my lord, but there is no pleading in the, my lord. Probably.
Upgraded item 22.
My lord. In Pune order is at page 65 to 68, your lordship. Lordship. Lost. From 89,
I got 20.
no. No, Lordship. My name is enlisted from your Lordship. Page 73 may kindly be looked into, Lordship. 73, Your Lordship. That is the voter list of 1989. Serial number 470, house number 157. Father is not there. But there is no specific year as well as the date you lost it, but in the written statement it has been described that father had expired. Lost it, and little price to you lost. I need to go there, you lost. Okay.
Item 3. Item 2.
May I please, Your Lordship? This case, Lordship, petition has been declared as foreigners. The input order is at page 30 because he submitted his WS evidence and affidavit, but at the time of argument he was absent because he was undergoing a treatment for his mental wellness. He could not produce any original documents, only the Xerox copies he produced. Yes. Lordship, I want to take. Actually, I want to take the advantage of this amendment act. Lordship, Citizens Act. Okay. Try করুন যেটা কেউ তাহলে ট্রাই করেছে মানে আপনি অ্যাপ্লাই করুন ঠিক আছে
And that certificate does not impress us.
Can you remand back the matter because he could not produce any or
No.
only photocopies is
That's not the reason. You see, if he is mentally unsound,
yes.
he could not have given you instructions.
No, because till now I'm not, I didn't get the inspection also.
Then you
Contact
could not have
list.
filed it. You see, as a
Because
counsel,
till
as a
till
counsel,
now
you can't say that you didn't get instructions. Without instructions, you are filing.
but
as a
till now he is
petition.
undergoing treatment for his mental. At the time of filing, that time just somehow managed to write the affidavit, sign the affidavit. But
Yes.
after that, like
Yes. Mental illness of convenience. For instructions, he is good. For approaching the court, he is not good. And your doctor does not say that intermittently he can do his work. That doing his process. You fix it for hearing. In the meantime, you do whatever you want. You are not adjourning. So is that presented? See, what? Here call the constitutional petition. Just for hearing also. Okay. We are fixing for hearing. Please correct the date after some time.
Okay.
No, no.
Seventh of May.
Okay.
Item 3,
Yes, you wanted an adjournment.
Lordship.
Just wait. Which page is the opinion?
74, Lordship. Mother's deposition is there, Lordship. Mother came and deposed.
Mother came and proposed. Is
Lordship.
there any voters list of you along with your mother? No. Which page is the evidence of DW2?
Lordship.
Which page is
DW2,
the evidence?
DW2, Lordship, Gaubura. And that's page 60, 69, Lordship. Page 65, sorry, Lordship, Gaubura. Deposition.
So, mother. But this is HMI. You're admitted it for hearing.
Lordship. Lordship.
item 4,
Obliged, Lordship.
The daughter has a lot of patience.
Yes, Lordship.
That's the wonderful thing. Four. Item 4. Now, here's on call for the petitioner. All the respondents are submitted. For ends of justice, the matter stands adjourned today. It is made clear that if the petitioner remains absent on call of the next date of listing, adverse orders will follow. Next paragraph. This from 29 April.
item 5,
May be taken next week, Monday. This may be taken next week. Next week is a holiday. You choose a date when we should come. Okay. Choose a date. We'll have a bench.
After vacation, minute.
After vacation. No, but on request, we are sitting in the vacation also. How's the same order? Heard Mr. and Islam learning counsel for the petitioner. Oh, sorry, Mr. Madhav. Heard Mr. Madhav and counsel for the petitioner. Same order, fix it for hearing on.
Item 6.
Yes, Lordship, yesterday we have circulated adjournments legal, Lordship, and matter may be adjourned for the day.
Okay.
Lordship may fix it for hearing, Lordship.
Lordship, just see the records.
Yes,
Just
Lordship.
count. Same order. Heard Mr.
A. Rahman, Your Lordship.
S.
A. Rahman.
A. Rahman.
On behalf of A.W. Aman.
Appearing on behalf of Mr.
A.W. Aman, Your Lordship.
A.W. Aman, learned counsel for the petitioner. Is the matter for hearing on. 5th of May.
Yes. Highly obliged.
Item 7.
Right, Your Lordship.
Yes.
My lord, it is of 2019 case, my lord. LCR has received, my lord. My lord, it may be listed for admission hearing, my lord. And to be frank, my lord, today I have some difficulty.
No
My
problem.
lord, after vacation, my lord.
No problem.
Sir, give us a copy of the petition.
We'll fix it for hearing.
Yes,
Which
Lord.
page is the opinion, Mr. Sheikh? Which page is the opinion?
The phone number to Lolo. Because yes.
70%.
My lord, page 77 onwards, my lord, up to 85. Before it's original number to lower at a copy.
Same order, Mr. M.A. Sheikh and counsel for the petitioner. This conference for hearing. We are admitting it for hearing.
My lord.
5th of May.
Oblige, Your Lordship.
Item 8.
Yes.
Lordship, my senior counsel is engaged in another court. Kindly pass over the matter for time being.
Time being. Okay. Ms. Verma, you look at the records here, in this last case. Here, this matter, yes. The, there's a certificate of registration which was discarded on the ground that it could not be read,
Not legible, Lordship.
not eligible. But if that document, I will check the LCR there. If the document is original. If the document is original, then perhaps the petitioner needs an opportunity to look at it. That's
Item 9.
My lord, this case, my lord, today I am not ready, my lord, but let the matter will come up after due vacation. my lord. Actually, in this case, my lord,
which page?
56, my lord, in your order is page 56, and Excel page 16. Lord, it was held that the linkage has not been proved. Actually, her mother was examined as a PW2, a DW2. So linkage, my lord, from through her mother itself says that she is the petitioner is the daughter of
Voters list along with your mother?
my lord.
Any voters list of the petitioner along with the mother?
No, my lord, no. The
Same mother?
mother examined, my lord, as DW.
TC date and transfer for the petitioner. So for the respondent. The records of the tribunal is received, which requires examination. Accordingly, court is inclined to issue rule returnable forthwith. So preparing and steps to be taken. This is the matter for hearing on 5th of May.
Most of them.
Item 10.
About 200 more cases are there in 2019. To be listed. Sitting an article.
That was just before the NRC process, Lordship, so maximum number of cases were filed. Because people feared that the names would not figure in the
So
NRC.
that's okay, but we're finding it difficult for adjournment.
Yes, Lordship.
2019, getting some difficulty in us.
After due vacation, Lordship may take them up on a war footing scale.
Maybe resolution. Immediately, Mullah is appearing, my lord, but today is out of session.
Which page in the opinion? Or shall you?
Case 52, case 52, my lord.
52.
Tribunal basically held that, my lord, prisoner could not establish linkage of his father with her grandfather.
We also tentatively have the same view. And Mr. H. Amit and asked for the petition. And so the response, same order. Which was hearing on so and so. Okay. 7th of May.
Obliged, my lord.
Item 11.
Lordship engaged counsel is unlike in another court. For the time being, it may pass.
Okay.
It is the damage court one.
Okay.
Item 12.
My lord, this matter may kindly pass out for
We
the
don't
day.
see you. Please be properly attired.
My lord, this matter may kindly pass out for the day.
Just one.
Lordship, at page 24.
No, there's some different problem here.
Yes, Lordship. Yeah.
Here we requisition two records. The petitioner is claiming that his brother was declared not a foreigner.
And
That is,
there's a
that is
registration.
the opinion at page 12,
Yes, Lordship.
but that record has not come.
Lordship, even there's a registration certificate, they may even think about the Amendment Act, Lordship.
That is for them to understand. But so far as we are concerned, we have to call for that record.
So Lordship, I call for the records. Of the second, of the first.
First case, 553 is
Yes,
not there.
Lordship.
284 has come. Both sides are represented by order dated 10/2/2020. Records of two cases were called for. Full stop. Though the records of FT within bracket 3, case number FT-284/16 has been received from the Foreigners Tribunal 3rd, Dhenmaji, Jonai, but the records of FT capital C dash Roman 2, case number 553, public 2015. It's page 12. Huh? Is not received. So accordingly, the registry shall also represent the records of page 12, FTC case number so and so. So the requisition may be sent by email to the following email address of the learned tribunal. Next paragraph. List on so and so awaiting receipt of the tribunal's records.
Item 13.
You want to time, no?
Yes, right.
You need your brother.
My pleasure, Lordship. BK Das is leading in this case, but he is suffering from illness, Lordship. So, yes, Lordship.
Look at page 42.
42.
One page is missing.
Oh,
Please, correct the problem. You take her number, send one copy to one. Look at page 9. 42 page 9.
My class and I have done a mistake.
Can you come to discussion at page 46?
Yes,
On the-
Lordship. Paragraph 7, Lordship.
Huh?
Paragraph 7.
Hi, 7 onwards.
Yes,
You
Lordship.
see what has happened here? Everywhere the voters list is being referred to as the voters list of the district Hojai. Correct?
Yes,
You,
sir.
you will find here examination chief 1997 Hojai.
Mhm.
Next paragraph 8, district Hojai.
Yes, Lordship.
Then next page, 2010 voters list for district Hojai. Then next is the voters in 2014 Hojai.
District Hojai.
Correct. Now next line in that page 47. The name of
Nagaon.
eligible voters is so and so instead of track number 1, number 1 from here, and the district also is Nagaon instead of Hojai. Now there is mistaken appreciation. Hojai district was created on August 15, 2015.
Yes, Lordship. This would be.
So the discarding of the you just go through it, we adjourn it, but we go through it.
And my petition is also not complete. I have asked him for a fresh copy. I don't have page 42 and the upper part of the orders is not properly xeroxed, Lordship. अपनी लोग साथ नोटिंग कॉपी बनाएंगे.
And then again, there is a small connect. Again, in the meantime, it was made a part of Nagaon. Again, in 2023, Hojai district was again separated.
Okay.
So that is the,
Maybe that has not been looked into, Lordship.
but that is the, but we give good copies.
Okay.
Details. What is the represented? The next person for the FT and Order Matters has submitted that the copy that was served on the standing person for the FT and Border Matters is not legible, and few pages are missing. So accordingly, the learned counsel for the petitioner shall provide copy of the petition with all enclosures, all legible copies of enclosures to the learned standing person for the FT and Border Matters within 2 days. Next paragraph. The participants adjourned today, this on, do it after the petition.
Lordship, I am on interim, Lordship. I am on interim, Lordship.
Lordship, would they have admitted and fixed for hearing, Lordship?
But if you don't have copies, it will
No,
be.
that, Lordship, 2 pages are missing. I have asked him to serve a
Okay,
fresh.
but if that is the issue, once you see that documents and that is the
Yes,
issue,
Lordship.
then it calls for the remand.
Yes.
Then require a hearing. That's fine.
Much obliged, Lordship.
Item 14.
No representation from the petitioner. Which one, the petitioner was also not represented when the matter was previously called on 17/6/2020. So for answer justice, the matter stands adjourned today. It is made clear that if the petitioner remains absent on call on the next date of listing, from adverse orders will follow. Next, all the respondents are represented. Next paragraph. List again in the motion column on 22/4/2026.
Item 15.
Exactly. Because petitioner is died, my lord,
Is it right?
already. My lord, authorized copy of death certificate is much earlier, but
The
subsequently.
legal representatives don't want to join.
My lord, what happened, my lord, they, given the information very lately, my lord.
No, no, it's not a question of late. I'm asking you whether the petitioners, the legal representatives want to substitute themselves in the rate petition or no?
substitute
I have to take information. Yes, sir.
Your name?
M.A. Chaudhary.
Mr. M.A. Chaudhary, learned counsel for the petitioner. Upon instructions, has submitted that the petitioner, namely Samar Ajiton Nessa alias Ajita Banu, has expired, and he has produced a photocopy of her death certificate, indicating that she had expired on 24/2/2023. Next one. The prayer made by the counsel for the petitioner, the matter stands adjourned to enable him to obtain instructions as to whether any family member desires to substitute themselves as the legal representative of the deceased petitioner, as there are consequences attached to an opinion of the learned foreigners tribunal. Next one, all the respondents are represented. The matter stands adjourned today. This one, you did after 4 weeks. So that you said that your certificate is made a part of the court. Clearment public.
Item 16.
Foreign justice matters and should not raise. Make clear that the petitioner remains absent on call on the next date of this week. Next, list on 22/4/2026.
Item 17.
Lordship, item 16, Lordship must fix it again.
Item 16, yes,
I didn't hear the date. 22.
April.
For my apologies, actually, we have misplaced the brief lordship, so it could be adjourned for the day lordship.
Item 17.
We have applied for reconstruction lordship.
Your name?
NZ Chaudhary lordship.
NZ Chaudhary. When you say NZ Chaudhary, right now, appearing on behalf of the Learned Counsel for the petitioner on the board.
Mr. Priya lordship.
Also had some responded. Pursuant to the orders passed earlier, from the record of the evidence received. Requires examination. Next, list the matter for a hearing. Which has the guiding steps to be taken. This is the matter for hearing on 7th of May.
Much obliged.
Item 18.
None appears on behalf for the petitioner. However, the respondents are represented. In terms of justice, the matter stands adjourned today. It is made clear that if the petitioner remains absent on call on the Ministry of Justice, those orders will follow. Let's go. This is again on 22/4/2026. Make it 24.
24 Lordship.
24.
My lord, I beg apology, my lord. Item 14, Lordship, I have been requested by Mr. B. Sandha, Lordship, to appear on his behalf and make a request to release the matter in the month of, in the first week of May, Lordship. He is having some medical condition, Lordship. But
It's already,
already,
yeah.
already,
22/4 Lordship had given the date.
I'm sorry, my lord, I missed the matter, Lordship.
Did you say that, heard Mr. D. Das, learned counsel, who appears on instructions from the learned counsel for the petitioner? All the respondents are represented. As the records of the tribunal agency, court is inclined to issue notice of motion returnable on 8/5/2026. We'll make it 11/5/2026. Listed in the admission column, 11/5/2026.
Yes, I'm obliged.
11/5. No, we change it. 11/5. Change that.
Item 19.
Next. In this case, my lord, the name of the petitioner's father appeared from 1966 onward, my lord. The book of the stock. Petitioner's name also appeared from
You want to? I don't know if it's up for you.
that from 1985 total. In the year 1997, she was marked as B, my lord.
Yes.
The learned tribunal discarded the evidence, my lord, on the ground that in her written statement, she stated that she has two brothers. And at the time of examination, she has stated she has one brother, my lord. On that ground, my lord, she split the entire evidence, my lord. Declare upon her to be a
Because normally it is expected that a member of the family will remember the other member of the family even in deep sleep.
But my lord, when my lord, cross-examination is taken, my lord, what I have seen, my lord, the persons become so nervous, my lord. I have personally seen this.
We don't know with that, don't have that experience.
No, my lord,
See,
madam,
that exactly is the art of cross-examination. If a lawyer cannot make the other side nervous, he's not a good lawyer. Do you do cross-examination for the intent of not annoying the other side witness? If you can say yes, file an affidavit and we'll allow this. But you will never cross-examine a witness to annoy or to break him as a good witness. Because we understand that these mistakes happen if you are a trained witness. You are a tutored witness and you come and then you forget everything.
Otherwise, my lord, there is a GP certificate, my lord, Gauhati certificate, my lord. And one of the author has been examined.
Ramura says he does not know you. DW4, Ramura, DW4.
Yes, my lord.
Yes.
My lord, at this stage, my prayer is that, my lord, matter is fixed for admission hearing in any other day, my lord. Otherwise, there is a Jamabandi also, my lord. Although Jamabandi was obtained after the opinion, my lord. And her elder brother also deposed as the W2, my lord. No, the W3, my lord.
When is your father's last voter list available?
My lord, from this petition, my lord,
1997.
1997, my lord.
Hello. Is the date of your marriage available anywhere, time or year of marriage available anywhere?
In the year 1982, my lord.
82.
82, my lord.
If the story doesn't match. If your marriage is the year 82, then your story doesn't match.
Page 7, paragraph 15 here, 82,
Then,
83.
then we don't have your story is not complete then. Which page is 1997 voter list?
1997 total list, my lord. Page 24, translated copy, ma'am. Type copy,
24.
24.
Sorry, we're not getting a connect with you and your parents. The evidence of your brother.
Yes.
Has to be discarded because your brother did not, has no connection with you in any of the voters list.
My lord, because
This is a proceeding which was not appropriately handled in the tribunal, but still there's a disconnect. Even if we find that there is a connection between your DW3, your brother and your father, but that snaps because of the fact that there is no connection with you.
my lord, because on enrollment of her name in her parental house, my lord. She was married, my lord. So, my lord, she did not get any opportunity, my lord. And my lord, at that time, enrollment 21 years. My lord.
No. 89, it was 18 years.
No, my lord. Her name first entered in the voter list in 1985, my lord.
Yes.
So at that time, it was 21 years, my lord.
No, because you see, your name appeared in 85.
Yes, my lord. Page 27, my lord.
Then your age was 22,
23.
23.
23.
So 23 would make your
And if her marriage, my lord, was in 82, my lord, that is 3 years at the age of 20, my lord.
so 87 you were 22,
85, my lord.
85,
85, my lord.
85, and your marriage is in
82.
82, so
Means she was around 20, my lord.
around 20.
And at that time, 21 years, my lord.
That time. You are relying on any authority? In support of your case, you are relying on any authority?
My lord, at this stage, my lord, I do not have any authority, my lord.
Okay. Yes, Ms. Verma.
Authorized certificate lordship, lecture 13, page 41.
You speaker,
Authorized certificate at lordship, page 41,
41.
41, and lecture 13 lordship. The finding given by the member lordship will find at page 71. Exhibit E lordship. It says, is the certificate dated 24/7/2015 issued by the secretary so and so, and whose age is so and so, And when he came to depose lordship, the OP has produced the issuing authority of the said certificate as defendant witness, in short DW4, and has deposed that he has been working as secretary of 57 Isabgaon.
No, this is page, if you are referring to this page,
I'm then
42.
again coming to the,
you are referring
32,
to page 42,
page 72, lordship.
72.
72, lordship. The DW4 has deposed that he does not personally know the OP of the instant case and had identified the petitioner. Accordingly, he issued
No,
said certificate.
No, this,
He
you are
has
referring to
not
page
brought
42.
any record to prove.
No, you are reading page 42.
Yes, lordship.
No, 42 is Gampura, that is DW2.
DW,
DW4 is Gram Panchayat Secretary.
lordship, I
Gram
missed
Panchayat
it up.
Secretary came for that GP certificate.
Yes, and that is also not admissible because that was
That is page 40.
for page 40. Lordship, actually the translated copy came to me.
Huh.
Page 40,
This is DW4.
for lordship. And it would not have been admissible because this is only for the purpose of NRC lordship. And then the other one, lordship, DW2 RGs. I thought the Gaupura had come for for
That
that
is
said
DW2. Gampura is
DW3
DW2.
is lordship. That is at page 42, lordship. It has the state emblem also, lordship, which is not permissible under law to be used by the Gaupura. Both the certificates which the petitioner is relying on lordship does not sustain his claim for citizenship.
Yes.
The linked documents to which the
Mr.
petitioner
Chaudhary,
is
is this
relying.
page 44, which is the entry you are relying on?
Twenty-seven, my lord.
Hmm?
Page 27.
No, page 44, which is the entry you are relying on?
Page 47. Page 14, my lord. Serial number. There is a tick mark, my lord. 1, 2. Number 4, my lord. Parapano. In the middle, my lord.
Serial number 4.
Serial number 4, my lord. 4, no, sorry, my lord. 8. It is 8 English.
And what is exhibit D? Yes.
Suppose linkage logic. Disconnect of the documents with the submissions.
always tell us a document which is not there before the tribunal. We have spent a lot of time and then we came to know that the document we are now producing, this Javamandi, is few days before the filing of the writ petition. You should tell us those things.
Not
We are
sure.
unnecessarily spending time. We asked you that question about that Javamandi. You did not say that it's a post.
No, my
opinion
lord, it's
document.
at the very beginning, my lord, I pointed out this thing, my lord. It is, of course, post, the after opinion, my lord.
And whenever we are intently trying to look at the documents, it's the document worse than what is there in the record. You exhibited a, what you call a revenue receipt. The revenue receipt was rejected on the ground that it is not readable.
Right.
In the High Court also, you have produced the same document. Here also, page 23 is not readable. The document is not readable before the tribunal, not before us. We can't help you. You don't find a connect. You don't say anywhere about the relevant dates, which are very, very relevant in your case. You come and say that your father died when your fourth son was born. When your fourth son was born, we don't know. The mutation in 2019, this step becomes questionable. Your revenue receipt we can't read. Even if you have a good case, you are destroying your own case.
Oh, my lord, that is the revenue receipt which was initiated.
How do I read it? Can you read anything
No, my
written
lord.
there?
But
you
there is
read?
no other option also.
We understand. If you can't read this, how did you translate? How did you type it in English? You destroy the correctness and veracity of your own evidence. When it is clearly rejected on the ground that it is not readable, still you produce the same document, unreadable document before us. Get the orders in chambers. Make it CV. But Mr. HMR Chaudhary and for the petitioner. So and so for the respondents. This is answerable. There's something very strange going on in this tribunal. That's why we are confused. We are looking and turning pages. Thank you to read documents for you to see. In the meantime, we take a break and come back. You see, unless you you do something for your travel, becomes very difficult. Your facts, kindly Gopit will show it to you. We'll tell you the sequence. There is a date on which evidence on affidavit by DW1 is filed. On that day, perhaps the documents are not there. The compared documents are in sometime in 2017. Then there's a cross-examination which is after that. So that means when the affidavit was filed, the original documents were never taken by the tribunal. The compared documents is there. So that's why at times we are losing track of what is happening. Because when I'm looking at a document, I'm also looking at dates. It's not matching, so I'm going back to the evidence and the cross-examination and coming back. So the tribunal doesn't pass an order to return the documents. So somebody comes at a date we don't know. Rather the date is there on which it is marked as exhibit compared with the original. How is this the tribunal is running its office?
At page 43 compared with 17 to 17.
17 to 17. That means the tribunal returned the document before the document was appreciated. And that is why the evidence was rejected on the ground that it's not readable.
Let me go through them.
Please go through it and the order sheet. I have not been able to see the order sheet. If there's any order for return of documents. If before appreciation the documents are taken away, the parties suffer.
Okay. The connect is missing actually.
I don't know. You go through it. Take a break and come back.
Yes.
And
I'm sorry, Lordship is not feeling good.
no, I am always feeling good.
No, just
These are
problematic in the working
These are part and parcel of
life.
everyday routine.
That's true, Lordship. But only item number 8.
You've seen that?
Lordship, I didn't get time to see Lordship. No. Your item, your to know.
No, the other item which
A2.
is not legible.
I couldn't find the date in the order sheet, Lordship.
It's not there.
No, Lordship.
Do you understand?
Lordship, that didn't strike to me at all. Lordship looks at the record
No,
reverse,
the
in a
date-
reverse manner.
No, the dates always I have to take notice. You know, when the doctor, you see, otherwise it doesn't come to the notice, but here it was rejected.
Yes,
So
Lordship.
when it is rejected, then we scrutinize the document.
Yes, Lordship.
So that there we found that.
Lordship.
We don't know, both of us will debate over it.
Yes, Lordship.
We'll, not, sorry, I used the wrong word. We'll deliberate on it. Yes,
But only my small cry before Lordship, my lord, item number 8, my lord. But can it be taken after vacation, my lord? Some problem I have got. Because that last order,
so it's a wonderful way to tell that tell that the court is having some difficulty and then
no, my lord, since I'm sorry, my lord, in earlier, my lord, this record was called for. Then it was not listed because of the COVID-19 method.
Now it has been listed, my lord. Now whether the person has been pushed back or she's remained, that I have to inquire, my lord.
You say both sides are represented. Item number 8. Both sides are represented on the prayer made by Mr. B. Chettil and counsel for the petitioner. The matter stands adjourned today. Please stop. Your date after vacation.
I'm extremely sorry, my lord.
Dr. Brief had asked me to go through the records, Lordship, on this matter. It's taken time now. Mr. Chetri has taken
No,
time.
but still, this is,
That matter, Lordship, just so that this one,
yes. The document is there.
it is there.
Just make a note. We will forget when the matter next comes.
Yes, Lordship. You find it in that. The registration document is there.
Yes, please bind us on the next date so that.
Item 20 for motion.
May I please your Lordship kindly pass over the matter for time being. The engaged counsel is on leg at court number 10, Lordship.
Just wait. Okay, after some time.
Oh, bless Lordship.
Item 21.
Can be faster for the day, any day.
Just a moment. We'll admit it for hearing. But Mr. A. Das Gupta, Learned Senior Counsel, assisted by Mr. J. U. Ahmed, Learned Counsel for the petitioner, and so for the respondents. Pursuant to order passed earlier, the records of the tribunal is received. It requires examination. Accordingly, court is inclined to issue rule returnable forfeit without requiring any steps to be taken. This is the matter for hearing on the date for hearing. Okay. Well, okay. Well,
Item 23 for motion.
This matter wrongly listed for motion. Notice already issued on first motion. And PCR is also on that.
it's okay. If you're ready, we'll take it up.
Well, this motion has already been completed and
So
he
it's okay, doesn't matter.
doctor come in the admission column.
It's okay, it doesn't matter. You think that this is admission and you make your submissions. How does it matter?
The matter relates to declaration of foreigner by the.
So that's you have any other matter.
The industrial issues matter. 3 or 4 matter.
Which item is that?
Probably one substitution.
Okay, we'll take it up at 2. We'll take it up at 2.
All right.
Yes, Mr. Paul.
The petition was declared foreigner by the Learned Tribunal by an order dated 4/6/2019.
Yes.
Annex of 4. Thereafter, my lord, we have filed a review petition before the Learned Tribunal on the basis of a certified copy of voter list which was prior to 1971 relates to the father of the present petitioner, which has been discarded by some making of observations. Those are now attainable in the parameters of law, which so we have impugned the order passed on 2/8/19 Annex of 6 at page 53 onwards. 53 and 54 the impugned order passed in review application of the petitioners.
This is a trial which is horribly conducted. You don't even know how to conduct a trial.
Even in the opinion, it's stated.
See, this is during investigation. They produce this document. This is a token for migrant.
Yes, Lord.
The registration, first name I could read, but this second name in the column 1
Yes, Lord.
is Dilip Burman. So Dilip Burman is his father. That means maybe the grandfather came. First name I couldn't read. This is along with him, they came. So here I can't read.
I can read Dilip and Son. That's it.
Yes. So Dilip is a migrant who, and this document was produced at the time of investigation.
Yes, Lord.
Because nobody took care to prove this document for the petitioner. That's one. Second is the first two flags. '52.
Yes, Lord.
If the migration is permitted and they
Normal
purchase this
sub-register office
52,
level.
there's a link.
Yes.
Next document you will find it's schedule of 58.
'58, Lordship.
This is there. And now what happened was during the trial that 71 document was not produced. 71 document was produced in review.
Yes,
There was a delay in the making of review, but it is not 30 days of ex parte. The review on any other ground.
Yes, Lord.
So this is not to vacate the ex parte opinion, but to review on any other ground. And this was rejected. If you can come to page 53,
54 is the operative part. The order of the Honorable Apex Court has been wrongly applied in this case.
correctly applied.
No, and there is a civil engineering case in paragraph 43 and 44. I have a citation hard copy before your lordship. In this case, limitation is not applicable in the case of tribunal. Only courts, law of limitation. That is observed by the Honorable Apex Court.
Don't tell us those things.
We have a,
The limitation is already prescribed. It's well defined. Have you read section 29 of the Limitation Act? Have you read it?
No, I am just going through as per Impune.
Go through your citation. Keep it going. Section 5 also does not apply and this also does not apply. Correctly apply. Joyce, correctly apply. Here what happened was page 54, last line, last para. You have seen the default on locus standi of the applicant, so as to no merit in the case. Because question of locus doesn't come here. You wrongly applied the terminology of locus. But having gone on merit,
These two documents would have helped Lordship.
because if they go on merit and decide the matter, and reject the document, then it affects the merit.
Lordship may consider remanding it and for reconsideration of these documents, Lordship. These documents, they can even go for the amendment act, Lordship. The Citizenship Act will,
No, it's not even required.
and even that period, Lordship.
No, even if that is not required, because once some migration program is given, that migration is allowed, become a citizen, you don't have to re-register yourself.
Yes.
But this was never proved. This is not even case of Mr. Paul. Nobody had time to read the Stanford records. We are the only ones to read the Tribunal's records.
I deeply appreciate it, Lordship. Have been great. There would have been a different opinion there.
Oh, so far as Your Lordship will find the verification report in page 37, which I have annexed, wherein she has been also shown that born in Betagaon, page 37. Verification report.
Make a difference.
Just citation.
That's
Make a difference.
right.
Of physical matter, even if born in, some would not make her or him, Indian citizen.
That's perfect. Paragraphs 43 and 44.
Agreed, Lordship.
This review application is a subsequent application, and main challenge is against the order dated 16/6/19 on merit. As per this citation has been relied in input. No, your lordship just asked me to produce that, and that is also relied in the input order itself. No, I have not interrupted, my lord. I was only agreed with my learned friend. That was yes. No, that doesn't mean that we have not challenged the original declaration of foreigner order. No, actually, my lord, what happened in this case, we have approached this honorable court by challenging the opinion of the landed tribunal on merit of the order dated 14/6, annexer 4, 16/4/6/19. That's why we have challenged the both. So when a first order is apparently wrong, if yes, because when the first order is apparently found to be wrong in the eyes of law, there are so many errors, my lord. If you lordship will consider it in detail in the order dated 4/6/19, annexer 4, page 38 onwards. Then your lordship have already examined the TCR also, and wherein the original cell deed of the father of the petitioner has been examined, produced in original, which has been discarded wrongly by the learned tribunal. So that is also a subject matter of challenge. We have pleaded in the written, so many factors, then you not have to go to detailed hearing of this case again. Paragraph 11, lordship will find DW1 and DW2. DW1 and DW2 are deposed in their cross-examination that was not rebutted in cross-examination of the aforesaid witnesses with regard to our residential status and our identity in the aforesaid localities. Evidence of DW1 and DW2. Thereafter, my lord, the honorable court has taken the power of cross-examination under section 165 of the Evidence Act itself. And the questions, those were put to the proceeding and the concerned witnesses was not incriminating against the present proceeding. And petitioner during the course of trial, and which cannot disentitle the citizenship of the present petitioner in view of the version of the DWs itself. Therefore, my lord, learned tribunal has not placed any reliance upon the certificate of Gram Panchayat with regard to link. And so far as the judgment of the Honorable Appeals Court passed in Rupjan Begum versus Union of India, reported in 2018 1 SCC 579. The Honorable Supreme Court, in the interest of justice, only the certificate can be treated to be the has been held that it can be treated to be the linkage certificate. But while expressed its opinion by the learned tribunal failed to disclose any reason why the said certificate is not relevant in her case, which is the linkage certificate of Panchayat certificate. Annexure number annexure number 13, page 64. Exhibit the document exhibited by the proceeding itself, and more particularly the proceeding is depends upon the only engaged counsel. He is a completely illiterate person, only housewife. My lord, TWC is Gauhati. And there is more interestingly, on the basis of main challenges, page 37, my lord, in my case, page 37 of the writ petition, where in the verification form, on the basis of the reference has been instituted against her in the foreigners tribunal, my lord. Here in in column number 5, 4 and 5, it is recorded that she was born in the year 1962, and in place of birth is Betagaon, post office Paniali, Tongla. So the verification report, Annexure 3 itself is sufficient to prove her citizenship before the tribunal, and there was no reference ought to be proceeded against her. And this honorable court, division bench of this honorable court in Manohara Khatun, there is also a citation that without proper verification of any proceeding cannot be instituted. There is also a certified copy with myself. And after proper verification, if required, proceeding can be instituted. No. That may be, my lord. That may be. But one thing is that. Okay.
Mr. Fine,
My lord.
we had expressed our mind to Ms. Verma.
Yes.
We see no point in hearing because we have been distracted from our view already taken. We close the matter, we'll pass out as in chambers.
other possible discussion. Madam, one more humble prayer before Lordship. Whatever happened with regard to my submission in regarding to the order passed in improved review application, but this order should not, this honorable court should keep much due caution with regard to the order which has been original order, which was passed on 16/6/19 by the learned tribunal. And in terms of the on perusal of the TCR, whatever you lordship express your views with regard to the
We
error.
told you,
of
Mr. Paul, you are distracting us.
So kindly,
If you insist on the challenge to the original order, then the writ petition has to be dismissed. We gave you a sufficient indication, but you still insist on that.
no, I am not.
You, number one, you don't understand things. Number two, you are not prepared. Number three, when we tell you that when we are making deliberations in your favor, you are trying to interject and showing us the law.
Humbly obliged, sir.
So please don't distract us.
Obliged.
We find your assistance not
Sorry, sir.
able for the
Extremely, sir.
not appropriate for the petitioner. We take our own call.
Obliged.
You were understood if you have made any submission in favor of your petitioner. In fact, we have told you, you are demolishing the case of the petitioner brick by brick. Pass orders in chambers, we will get it tomorrow.
Obliged.
You have updated one of the items.
Upgraded item for orders, item 32 to item 40.
I have pleaded lordship. I'm appearing in item number 32, my lord. I have filed one IA, my lord, for substitution of legal hair, my lord. IA 1095/2026.
Any objection?
No, Your Honor.
For the application. Heard Mr. A. Bhattacharya, then counsel for the applicant. Also heard Mr. D. Bora, learned
Respond number 2.
counsel for respondent number 2. State who is appearing.
So, Your Lordship, I don't.
For number 1, first time, and Ms. R. Bora, learned government advocate appearing for respondent number 1. Next paragraph. The learned counsel for the petition applicant has submitted that during the pendency of the connected WA 307 of 2024, the appellant, namely Vibhu Bhushan Deb Roy, has expired on 30/12/2025, leaving behind the present applicants as his legal representatives. So accordingly, by filing this interlocutory application, substitution of the applicants as the legal representative of the writ petitioner, writ appellant is straightforward. Is the word only. Next, having heard the learned counsel, the learned government advocate and the learned counsel for respondent number 2, the clear meeting this interrogatory application is allowed. Next part, this application stands disposed of. In the connected appeal, you say, heard so and so, in view of the order passed today in IS Civil 1095 of 2026, allowing substitution, 2 days time is granted, 2 working days time is granted to the learned counsel for the petitioner to submit the amended cost title. The AOJ appellate section for incorporating the same in the memo of the appeal and to update the CIS. Next para, list on.
Your Lordship, I'm being led by Mr. Kane Chaudhary on 19th or 21st of May, Your Lordship.
19. Right. Your name? Respondent number 3 in the writ appeal.
Item number.
Item number? These are corrected matters.
Interlinked matter, my lord.
So all will get adjourned.
Actually, the matter has been pending on the issue of maintainability of this writ appeal.
No. Are you doing the other matters or it?
No,
it
Your
will be
Lordship.
adjourned?
Only in 32. I'm
Only
only
in
in
32. Only in 32. Just wait then.
My please, Lordship.
33 then. 33.
My lord, I am appearing for the appeal, my lord. Item number 33, my lord.
Why is this connected? Mr. Bora? But this connected matters 32 and 33. No. Your Lordship, 32 and 33 are connected.
No. Actually, the issue on all this writ appeal is whether writ appeal lies against the order of a single judge in terms of in respect of labor court matters. So under 227.
So that is why it is connected.
That is why it is connected. So this issue as such is pending. So that's why I'm praying that this matter, all these matters be listed and be heard together.
Which case there is a judicial order to type all this together?
Lordship, judicial order in the matter led by Mr. P.K. Goswami, senior advocate.
34.
34, if I'm not wrong. 34, Your Lordship. I don't know, 34, there is a judicial order. Early orders are there.
Here there's no order.
Your Lordship, in item 32 to 40, I am appearing in item 40 for the respondent.
Yes, we don't find any order to tag these matters together. I don't know why it is coming together. We are not
Yes,
finding a
there is no,
judicial order.
there is no such judicial order tagging all these matters.
If any other matter is ready for being heard, we'll hear it. Item 32 has been adjourned for substitution. So 33, 34, 35, anybody is ready for hearing, will hear the matter.
I am appearing for 34 and 35. After,
So far as we are concerned, we are ready. Are you ready? If you are ready, start.
In this case, this batch of case, was heard in the court number 1. The chief point involved, so far I remember, whether the readable lie against an order. So,
Yes.
this case was tagged.
This case was taken, all the cases were taken.
It's okay. Here before.
Your Lordship seizes order dated 10th February 2025. In that, it was recorded that in other two writ petitions, the then Chief Justice had made a prima facie observation, what my learned senior had pointed out, the law point.
You also attended, no, sir.
Yes.
No, that's okay. We are ready for hearing. If you are ready, we will start the hearing.
So far the item number 33 is confirmed, my lord. I am praying before your lordship that matter take after due vacation, my lord.
The super item number 36 is concerned, probably this, your lordship cannot take up this matter. Because the judgment passed by your lordship. 36. Bappa Chakravarti.
Regarding item number 38, lordship, I have submitted my written argument. This is a part of the record.
Written argument regarding the maintenance.
May it please Lordship.
No, I think what was that? तो मैं क्यों पता this one ठीक है बोल देना अब पहले हमको उनके बोल no problem. Then we are happy. Yes, that is one of the orders.
When do you want? After vacation, let's see.
The way gets the vacation.
All sides including senior counsel for the respective parties are present. It has been pointed out that amongst this batch of writ appeals, comma, WA 240, the order impugned in WA 241 of 2023 is by one of us in the bench. Within bracket, KR Surama J. In view of above, comma, let the matter be listed before any of the bench without one of us. Within bracket, KR Surama J. Next matter. As agreed to by all sides, when did you want?
Second week mail okay.
Can we suggest a date?
26 May. Because in item note 35, one issue is that whether the research instituted is a falls under the purview of the industry or not. And the Honorable Supreme Court has already reserved the judgment in the state of Bangalore water supply, 9 benches. So, Lordship may have them the second week of May. Second week of May, any date.
19th May, my lord.
Okay, 19/5/2026. Fixing out 19/5.
Yes, sir.
Obliged. We have said all sides are present, including senior counsel for the respective parties. Hello.
Okay.
Yes, Mr. Nath, you made a prayer for which item?
Item number 31.
Lordship, I am online on VC.
One.
Item number 31. My
I
senior
am-
is appealing.
Okay, just wait for some time. There are 3 or 4 motion matters. We'll finish that.
As it pleases Lordship, I had just some difficulty. I had fixed a matter at 3:30. So I'm hopeful that it'll come before that. Otherwise, I may seek some indulgence from Lordship.
Please repeat again.
I was saying, Lordship, I had fixed a matter at 3:30, today because I thought 2 o'clock this will come. I'm hopeful it will come before 3:30. Otherwise, I may seek some accommodation then. If it doesn't come by
Just a moment, your
3:30.
voice is not very clear. It is very light. Just a moment. Yes, Mr. Nath?
So my senior is having as this case is fixed on at 2, so he has fixed some matter at 3:30. That is
Okay.
that is what he is indicating.
Okay. So matter
I
was-
hope I'm clear now, Lordship.
Okay, a bit better, but it is very light.
I was only saying, Lordship, I have prefixed something at 3:30 because I thought this will come at 2. I may not be able to take a pass over there because I specifically requested in light that I'm appearing before Lordship at 2 o'clock today. So if it doesn't come by 3:30, then I will, Lordship, request for an accommodation tomorrow or day after.
Okay, then we take it up. Motion matters will pass orders after that. Then, okay.
Grateful. May I, Lordship?
The item is item number
31, Lordship.
31.
31.
I am grateful for your indulgence.
The voice is very low. You're not hearing it.
Lordship is not very clear.
No, your voice is very low. We are not, it's not audible, in fact.
In fact,
Let my second coordinator see that. You are getting my voice clear?
very clearly, Lordship, it is so clear. I'm in fact surprised because there is no problem at our end. Maybe the audio level needs to be raised in the court.
I'll be missing. Mr. Nath, I'll be missing that.
May I reconnect? I can reconnect if Lordship wants.
So your voice is not coming.
I'm coming again. I will reconnect. Lordship, is the audio better now?
Almost the same, a bit better, but still the same.
I
Acha, just a moment, Mr. Nath and Mr. Kohli. In this batch, these are matters related to APSC, right?
APSC. Sorry. Yes, Madam.
Then she will not be taking up, so it
In
has to
one-
come up some other day without a bench without one of us.
understand, Lordship.
In one review petition, Lordship has already issued notice, Madam.
No,
Look,
we understand,
let's-
but she has said
Correct.
because she's
Correct.
connected with one of the matters.
Correct, Mr. Shah, APSC in that case. Madam.
That is fair, Lordship.
We're sorry, but we can't take it up. One of us, we can't take it up.
Can we
No issue.
play for tomorrow, Madam?
Tomorrow, Lordship?
The same bench.
Lordship.
Tomorrow's vacation.
Mr. N. Kohli, Learned Senior Counsel, assisted by Mr. D. Nath, Learned Senior Committee. Mr. N. Kohli, Learned Senior Counsel,
Oh,
appears through video conferencing, assisted by Mr. D. Nath, Learned Senior Committee Advocate. Mr. This matter before any other bench without one of us. And Mr. Ajay. Mr. Nath, you can move the registry to one if you have an urgency.
Lordship.
Yes, Mr. Kohli.
Grateful, Lordship. No date at the moment, Lordship?
No, we are not saying because it will be the Honorable Chief Justice, and now your
I
voice, when you are leaving, your voice is good.
am. Lordship, I have no role to play in that. Grateful, Lordship. Deeply obliged to Lordship, Ladyship.
Motion item 24.
Your Lordship, I'm appearing on behalf of Mr. H. Omwa. He is the legal aid counsel in this matter. He's out of station for some work purpose only, Your Lordship. Your Lordship may adjourn the matter for today and fix the matter immediately after his vacation.
Just wait.
Yes, Your Lordship. Yes, Your Lordship. Item 24.
His name is shown in the cost list.
Yes, Your Lordship.
And there is no record of any legal aid counsel memo appearance being filed. Please tell him that it is appearing as a legal aid counsel, then he'll have to file a memo. If memo is not there.
Big memo from Aldo. Ready to legal aid is a point.
It's not there. And in this case, we don't have a supplementary record because the Vakatama is here.
Yes.
Supplementary record is also not there. Showing memo appearance.
Subsequent of the.
Apologies, Your Lordship.
We'll adjourn it. We are not recording your presence, but we'll adjourn it. If you will be appearing, then please file a memo appearance.
Obliged, Your Lordship.
We just adjourn it today.
Yes.
None appears on call for the petitioner. How is J. Fang, how other, all respondents are represented. Next one for ends of justice, the matter stands adjourned today. List again on 11/5/2026. We are giving you sufficient time. In the meantime, you will find the appearance.
Obliged.
Item 25. May I please, Lord. But this matter may kindly be taken after vacation, my lord. I could not prepare, my lord.
Okay. Just keep it. Keep it apart. Okay, we are issuing a notice and then we are fixing it for admission. Both sides are represented. The records of the tribunal is received, command requires examination. So accordingly, issue notice of motion returnable on 14/5/2026. Without requiring any press steps to be taken. This is the matter in the admission column on 14/5/2026.
25, my lord. 45. Obliged. Item 27. Case 94 is the impugn order. In this case, two orders passed by the learned tribunal against the petitioner include different proceedings. Both the proceedings simultaneously run. In one case, already your lordship passed order. Order. One case was listed on 25/3, and your lordship has called for the record. Same tribunal has simultaneously proceeded two FT cases, and on the same day, both the cases order is passed.
Right. 94 is an opinion.
Yes.
On the same day, another opinion is passed by the same time. With this, that order, earlier order is where?
It is not annexed here, lordship.
Next, otherwise, how will they find it out? They have to give him the other petition.
Lordship, 1739. 1739. There are 17. There are 17.
Page 94.
No, there are 75.
Here we say, para 4, requisite extra copies of the petition along with copy of read petition in WBC 1739 of 2026. Be furnished to the learned counsel for the respondents by within 2 days. Even that copy also, otherwise he'll find it difficult to get instructions. Same date. 27/4/2026.
There are 17 I have mentioned. There are 17 I have mentioned.
He will not get right that he doesn't have time to look read like this. You could have annexed the document, he would have seen it and got the instructions. Now you'll have to give him an entire set of the read petition. Same date. 20.
Item 28 for motion.
Yes.
The impugn opinion lordship, the case 125.
125.
25. Annex 29. The contested cases.
But this
And Ahmed.
And I have learned counsel for the petitioner and so info for the respondents. Page 125. Opinion dated 2/1/2026, passed by so and so in FT case number so and so. I am making reference number so and so. Thereby declaring the petition to be foreign law 25/1971. Notice for a return in 4 weeks, extra copies for the record. Fear for bail is opposed by the government, time for the appeal border matters. I think the promotion, 10 days time to take. Make it 15 days. 15 days time to take bail of rupees 5,000. These are restricted now. Superintendent of Police Border,
SP Bozali.
Bojali. Okay. This time.
Within 15 days. Within 15 days, appear. Diploma.
Item 29 for motion.
Please, Mr. Suleiman.
Next question. Expert opinion doctor. Improve page. Order page 62 doctor.
Page.
Page 62. 62.
Okay. But Mr. James
Expert.
Suleiman, Learned Counsel for the petitioner and so and so for the respondent. Team give it to the satisfaction to a bail to the satisfaction of Superintendent of Police Border, Dorong.
Dorong.
And what is your ground for not appearing?
Page 11.
Page 11.
It's a miscommunication between advocate and the petitioner.
Mr. Fan, yes, come within. But there's a delay again. By in this case, the notice was served
Yes, brother.
on 12/6/25
Yes.
and 12/12/2025, the matter was disposed of. Can we give an opportunity to the petitioner instead of calling for the records and then examining it?
Last one.
Last and within 60 days,
They have to file the my lord on time.
we are giving an opportunity. Within 60 days, it has to be disposed of. No adjournment. Even if you are ill, you will not get an adjournment.
One.
Correct. You have confidence on your client.
Layman lordship.
You have no confidence.
Illiterate.
You make them understand because we'll make it very stringent order. No further opportunity, no adjournment. By filing this repetition in Article 226 of the Constitution of India, the petitioner has assailed the opinion dated, ex parte opinion dated 12/12/2025, passed by so and so in page 62. Next paragraph.
Tribunal.
the
But more.
learned counsel for the petitioner, by referring to the statement made in this writ petition, has submitted that the petitioner was served with the notice of appearance only on 12/6/2025 and had appeared and filed his written statement in the month of August 2025, and thereafter filed his evidence on affidavit on or about 22/9/2025. And he had also filed evidence on affidavit of PW2 on the same date. He submitted that, however, subsequently there was a default in appearing before the learned tribunal, and the learned counsel engaged also did not take steps on time. So resultantly, the ex parte opinion was passed by the learned tribunal on 12/12/2025. So accordingly, it is submitted that the petitioner be granted one last opportunity to produce his witnesses for cross-examination. It is also submitted that the petitioner was intermittently ill, for which he could not take steps. After that, we say that, no? And therefore he pays two. Next, the learned standing counsel for the FT and bottom matters has opposed the clear made in the writ petition on the ground that the reference case was registered in the year 2012. That the notice of the proceeding could only be served on 12/6/2025, which is submitted that as the petitioner indulged in dilatory tactics, the learned tribunal had rightly passed the ex parte opinion in view of the provisions of Order 3 within bracket 14, of the orders within bracket tribunals, bracket Act, Order on 1964, which provides that the proceedings should be disposed of within a period of 60 days from the date of receipt of reference. Next paragraph. We find force in the submission made by the learned standing counsel for the FT and border matters. First of it also cannot be disputed that the petitioner had taken adjournment on a few occasions and and that he was also not represented before the tribunal on all dates. First of the written statement appears to have been filed after the learned tribunal gave a last opportunity of filing written statement. And the written statement was filed on 14/8/2025. The next date was fixed on 27/8/2025 for evidence. To stop on 27/8/2025, the learned counsel for the petitioner had paid for adjournment, and the matter was deferred to 10/9/2025. Again, on the said date, the learned counsel for the petitioner paid for adjournment, for which was allowed, and the next date was fixed on 22/9/2025 as a last chance. To stop on 22/9/2025, the petitioner had filed evidence on affidavit of DW1 and DW2. Where certain documents were marked as exhibits and certain documents were marked as annexures. And on the petition being filed on 13/10/2025, prayer was allowed to submit additional affidavit. And the next date was fixed on 10/11/2025 for additional affidavit, for cross-examination and for argument. As a last and final chance. So how on 10/11/2025, the petitioner was absent. And his non-counsel paid for an adjournment which was allowed, and the date date was fixed on 1/11/2025. To stop on 1/12/2025, the petitioner was absent, and the prayer for adjournment was rejected. And thereafter, as the petitioner did not turn up, the case was fixed by ex parte hearing on 12/12/2025. Either as it may, circumstances when the petitioner on the file evidence on affidavit of PW1 and PW2. Those are the conceptual opinion that should be given one last opportunity to appear before the said learned tribunal. Apart from finding further evidence on affidavit of such other witnesses, if appropriate, shall also present the DW1 and DW2 for cross-examination of the next hearing. Specifically, the resolution of further evidence on affidavit and presenting the DW1 and cross-examination. The Indian will, without finding any fault with the Indian opinion, located in witnesses 2 to 26. same is conditionally set aside. Conditions are the petitioner shall appear before the unit member of foreigners travel to first member the interact on 15/5/26. On such appeals, the petitioner shall produce a certified copy of the order and also file evidence on evidence of such other witnesses as is for the lawyer. Next, petitioner shall also produce deed of one into the for first example on the set date of appearance. For the petitioner shall wait for further directives or orders that will have by the foreigners by the foreigners tribunal. Next one. The court is further inclined to provide that in the event the petitioner fails to appear on the date fixed, this conditional order would stand lapse by effects of fine and would be rendered non-accessible. And because on the expiry of 15/5/2036, the opportunity granted to the minister, the actions stand for such an event, the opinion, dated 12/12/20, right, last page one shall stand right. Next part, however, in the event the petitioner completely the directions of the court, herein dispose of the reference within the time permitted under order 3, the orders orders from an item. Unique to this case, property salvation do not cannot be declared as a resident for a user. It cannot be extended to any level. Condition there. So we are conditionally allowing you to appear. No adjournments. And if you don't appear on the date fixed 13/5 with DW 1 and 2 and don't file your evidence, then the court will pass appropriate orders. And this on lapse of 13/5, the opinion would again revive.
Next meeting, how many days? How many days will appear? When he will appear? Date is fixed by date.
13/5 on that date. On 13/5, the date fixed on that day, you're ready with your witness.
13th of May, 13 May.
On that day, your two witnesses have been examined. Doesn't have for cross-examination.
Time being item 11 for motion.
Yes, Lordship.
Yes.
For the order at page 21, my lord, of court. 18 onwards, my lord. Page 20 operative part, my lord, on a careful perusal.
Yes. Yes.
Only thing that, my lord, he was unable to produce the document in the hearing. That is the thing, my lord. Otherwise,
Which document?
that is, my lord, the document regarding his identity card and which has been issued in 1964.
Come to page 23.
Yes, my. 23.
Just shows that if you have an identity card,
Yes, my lord.
but this is not a registration certificate.
What
Even if
They are refugee, my lord. There is refugee card, identity card, my lord.
see, being a refugee and being a citizen are two different things.
Yes, my lord.
Even if we send you back, how would you prove that you have registered yourself as a citizen of India, you have requit your citizenship of another country?
There after 1985, their name has been enrolled in the.
The answer. The fact is that you must have registered as an Indian citizen. Where is that document? It's not there. At best, we can take advice and apply for a registration now because we don't see anything. You can just adjourn it. Give you some time to do whatever is necessary.
Yes, my lord.
Ultimately, if you don't find anything that you have shown yourself to be registered as a Indian, so time we just adjourn it. Yes, but that is probably what we can do.
Some lemon.
Procedure represented on the fair matron settling of the one of the petitioner, matters not withdrawn to this gain on. Give it after the. Make it 4 weeks. You can do whatever you want.
Obliged.
Item 30 for admission.
May I please, Your Lordship. My lord, Your Lordship may kindly peruse the order dated 2/2/2026, Lordship. It was submitted, the charge sheet was, supplementary charge sheet was submitted, Lordship, and this honorable court directed to produce the same. Lordship.
Yes, you have the case diary. But based on the investigation, the accused persons, they have been charge sheeted.
Yes, sir. But without body, recovery of the body, Lordship, if dead, Lordship.
But if
then
the body is not
finalization
recovered,
cannot be-
what can be done?
I leave it up to your Lordship's wisdom, Lordship.
No, because you have to show us the way.
Yes, Lordship. I am also
Even if
thinking
the-
about that, Lordship.
In case the investigative agencies. like
Because,
CBI or
Lordship,
CID.
Otherwise, Lordship, perhaps, Lordship, it is not impossible for Assam Police, Lordship, to recover a dead body, Lordship, if he was died, she was died. Because only due to poorness or povertiness of the lordship petitioners lordship,
No,
they have not
you-
given any lordship importance to.
See, it's very difficult to say. She is stated to have been burned down in a brick kiln.
Yes, that was stated by.
Are you aware of what would be the temperature in a brick kiln?
Nothing will do.
No, now you have Google, you can find everything. Just see the temperature in a brick kiln. Just check out. Doesn't cost you anything.
Mm.
900 to 1200 degrees centigrade. Nothing will be remain solution.
Nothing will remain.
Open up again. Momentum. I lost my daughter.
And
Nothing will.
not only is that, Mr. Here you see the I don't know whether you have seen or not, but the how can I Yes, I won't be able to explain because of our limitations. You see, if you can ask anyone about the manner in which brick kilns are cleaned, a brick kiln may have debris for hundreds of kgs at a time, and the ashes are pulled out. And it is next to impossible to have a forensic analysis of the ashes to find out the traces of human DNA in it. It will just impossible. At least we can't think of it. How to do it? Because if we pass an order, it must be implementable order. We are in no hurry that since the report has come, we'll close the matter. We understand that your family member is lost. So we are not insensitive to that. But you'll have to tell us a way and the manner in which it can be proceeded with. Otherwise, we'll have to say that since you are the victim or the aggrieved person, you will have right to be in the trial and to assist the trial.
Lordship, in the trial, nothing will be survived, Lordship, if body was not found. Because they will not able to file the final charge sheet also. Maybe, but
Circumstantial evidence, we
Yes,
have a
sir.
lot of judgments, even I have authored where the corpus directive is not the only requirement.
yes. You Lordship may dispose it, Lordship, by appropriate regular Lordship. Fine. Voting people often going to the government. Fine. देखिए बॉडी के कुछ मनुष्य का बड़ी पड़े বিভিন্ন নাম বডি কি মনে একটা একটা আর নিজের বাচ্চা স্বাধীনগত লোক বেশি একটা বেশি হচ্ছে সবাই মানে এরা শরীর থাকে মই যেটো ভাবিছিলো মোৰ কাৰণে হেৰি কিন্তু মানে তাৰমানে বহুত পইচাও আছে আৰু বডিটো নাইকিয়া কৰি দিছে মানে যি গম পাইছো বডিটো খালে ফিলিট হৈ দিছে ন মানে গম পাইছো বডিটো নাপালেতো কি হ'ব ইমান এটা বেছি ডাঙৰ কেছ নহয় ইমান ৰচি কেনেকৈ পাৰিব পাৰোঁ একো মাইন হাণ্ড্ৰেডটো 1200 ধেমালি কৰে লোহাই গলি যাব হেৰি ফুল দি পেলাই টেম্পাৰেচাৰ দিব লাগে ন ব্ৰইলাৰটো টেম্পাৰেচাৰ বহুত হাই থাকে তেতিয়া দুটাহে পাইছোঁ টেম্পাৰেচাৰ বহুত হাই থাকে ক্লিন যিবোৰ থাকে এনেবোৰ আমাৰ গা ধোৱা কৰে যিবোৰ কোনো টেম্পাৰেচাৰ নকৰে হেৰিটো থাকোঁতে একেবাৰে কিছু চিমনি থকা এনেকাইটো মইতো ক'ব নোৱাৰিম এইটো এটা এটলিষ্ট সমাধানটো ক'ব পাৰিলে কি কৰিব এইটো ক'লে মোক সিহঁতে আগতে গম পাম এইটো হেবিচুৱেল থাকে এইটো সিহঁতে গম পোৱা নাই কিন্তু দাম ভাবিছোঁ মানে অপাৰ দিছে যদি দি দিলে মই অলপ পেট্ৰলত থকা এইটো বুজা মাৰি পেলাব ইমান চিৰিয়াছ কৰিব
You have whether the final charge sheet has been filed. We can't close this matter. We'll have to keep it pending. And it's from here and from the petitioner. Next, our Bora submit. Submitted has produced the case ID. Copy of the online available SID capital, SID records as per CCTNS portal of the supplementary charge sheet of Sonapur PS case number 55 of 2025. While Sonapur PS charge sheet number 167 of the 2025 dated 5/12/2025, which was submitted against four accused persons. This the final charge sheet has not yet been submitted. The matter is deferred so as to enable the government to produce the updated status of investigation. Next, the copy of the available SID records are perused and rendered. The government committed again. Next, the government committed obtain the updated investigation status on the next date of the state. Next, the learned committed shall communicate a copy of this order to the concerned authorities just to send the updated status report of investigation on the next date of the state. Next, based on 5/26. This will be. Yes.
Order of final.
Fitting height for the status report. Yes, yes. Yes, Mr. Day, you had made a prayer for reading.
Item 42, supplementary item for orders.
May it please, Your Lordships.
Yes.
My lord, in this case, my lord, initially, my lord, an ex parte order was passed by the Foreign Tribunal, Nagaon. My lord, that was challenged before this honorable court, and this honorable court was pleased to dismiss it, my lord, on the ground of delay and the laches on the part of the petitioners. The petitioner approached the Supreme Court, my lord, and the honorable Supreme Court, my lord, disposed of the matter with a direction before this honorable court to, my lord, pay Annexer 5, page 85, to consider it if a review petition is filed, my lord. Accordingly, this review petition, my lord, Annexer 5, page 85. Second paragraph, my lord. A categorical stand is being taken before us that the petitioner was never served proper notice by the tribunal, and as such, he had no opportunity to challenge the same within a reasonable time. That being so, it seems to us that the petitioner should raise such a factual issue before the High Court in a review petition. The special leave petition is accordingly disposed of with a liberty to the petitioner to file a review application before the High Court along with the necessary documents. If such a petition is filed within 2 weeks, we request the High Court to not reject the same on the issue of delay and maintainability. So, my lord, accordingly, my lord, this review petition is filed, my lord. I have taken the grounds, my lord, at page 10, my lord. 10 onwards. My lord, my humble submission, my lord, for the full and effective justice, my lord, an opportunity is to be given to the petitioner as because, my lord, that the ex parte order has been passed. The petitioner was in jail when the date was fixed for appearance, my lord. Petitioner was in jail in connection with the FIR, my lord, and he could not appear before the tribunal on the date fixed and subsequent to that. And when he was in jail, ex parte order was passed, my lord. This is one of the ground, my lord. Ground number 1, my lord, I have taken that the.
Where is the certificate of the jailer that you were in jail at that time?
My lord.
Where is the certificate of the jailer that you were in jail?
That I have given an order of the session judge that the bail application was rejected, my lord.
That does not mean that he was in jail.
And I have stated in my read petition, my lord.
Where is that order of the sessions judge?
My lord. Passenger's order, my lord. Annexure. Bail page 66, my lord. Page 66.
But you see this, we took into consideration at page 76 of our order.
'76, yes. There are 5, my lord.
But you will have to tell us that when he was released.
My lord.
You see, he was taken into custody that you have shown, but he was released when? Those facts are not before us.
My lord.
You see, what is the date when you were released?
My lord, that release, my lord, order is not given, my lord. Subsequently, in the third week of, I have stated third week of June, my lord. Third week of June in the page 76, second line, my lord. Judicial custody till bail was released in third week of June 2018. About 3 months, my lord, he was in jail.
So, but if you're in jail, you'll get a jail certificate. So
My
that
lord.
he was in jail at that time.
Another aspect, my lord, that he was in, that is another aspect, my lord, due to expertise, my lord.
No, you get the expertise for the timing. You say that you had disability in appearance because you were in jail.
That the specific date is not given, my lord. But he was in jail, my lord, when the order was passed in May, my lord.
You are exercising a review jurisdiction not because of our own volition, but because of orders passed by the Supreme Court. So we have to see everything then. See, Mr. Dey, the reason we are not still in time is a very simple fact. Come to page 76.
Yes, ma'am.
76, paragraph 5.
Yes, ma'am.
The notice was served on 17/3/18.
Yes, ma'am.
You were not arrested then. You were arrested 3 days later on 20 March 2018,
Yes, ma'am. After 3 days, my lord.
after 3 days.
My lord.
So in these 3 days, you have to explain that you had no notice of this service. The process service reports have not been essayed. And the date on which you were taken into custody and released, that is not before us. So your situation from the last order has not changed.
My lord, 17 received, my lord, he received the notice, but on 20 he was arrested. So he was,
Before,
and the date for appearance is fixed to 7/4. 7/4/18. So he's supposed to appear before the tribunal on 7/4/2018, my lord. And on that day, my lord, he was in the custody, my lord.
before,
Up to passing the ex parte order, my lord. Thereafter also, my lord. So order, impugned order was passed, ex parte order was passed on 10/5/2018.
you were arrested. Your family members also know that there is a police case pending against you. Now, if you come to the page, same page 76, paragraph 3, see, here you say, in last 5 lines, in the month of June 25, when the police arrived at his house on so-and-so searching for him, his family members were informed about the ex parte opinion. That means you have family members.
Family members are there, my lord, they are
Nobody took
illiterate persons, my lord,
Nobody took
nobody is. Poor people and the illiterate persons, my lord.
But you have to show, we can give you time, a week's time to find out when you were released. You have to demonstrate before us. What was the record then from the tribunal? No, because Supreme Court order, it says that it will not be rejected on the ground of delay.
No, my lord, that is
Not
true, my
mention
lord.
everything.
We are not, I'm not on that. My lord, it is categorical statement, 85 Supreme Court judgment, opinion, order, my lord. Categorical stand is that being taken, being taken before this as that petitioner was never served proper notice by the tribunal. That is the statement. Only on that ground.
We'll have to copy
As-
the records and see.
As such, he had opportunity to challenge the, now it is admitted position, my lord, he was served notice.
But that is not proper notice in the sense, my lord. I
Proper
will,
notice
if
is
your
he
lordship
has been
wants
served
to,
notice,
I will
my
show that
He
this
has
is not the proper
accepted
notice. Because, my lord,
You see, you have not, it's not your stand
my lord,
that you are a master degree in English and you know only in the English and not SMS. You now say that the notice must be served in English also. How,
another thing is that indicating that the
SMS
burden is on the petitioner to prove that he is not a foreigner. That is also not mentioned in the notice, my lord.
not required.
It is, my lord, it is required as per the full bench decision, my lord.
No.
Yes, my lord. So far my knowledge goes, my lord, I have read the full bench decision, that is Muslim Mandals, my lord. That the notice should be including that he has, the burden is upon the
Then you can
petitioner.
challenge the notice. If the ground is that English, the notice was not sent in English, I couldn't
Well,
understand.
that is, I have stating because not proper, that is why, my lord. And the law says, my lord, order 4, rule 4, my lord, rule 3 is also saying that indicating notice should be given, indicating that the burden is upon the petitioner to prove that he is not a foreigner.
But language of the.
That is not in the notice, my lord.
It's not that the
That
service
should
was
be
wrong.
there. It is
Notice is wrong. The language is clear. Petition was never served proper notice.
Yes.
Yes, notice was
In
not
that sense,
properly
not
served. That
proper.
is the point. That is
Notice
the
is not properly served.
If the notice is not proper, that will be a different aspect. The notice is not proper, that is a different aspect. But it was not served properly.
If the notice is not proper,
Yes. Never served proper notice. Yes.
proper notice, that the notice is not proper.
Yes.
Proper notice has not been served.
The categorical statement being taken
Yes.
before us that petitioner was never served proper notice.
Proper
That is
notice,
different.
yes, proper notice.
Now,
That notice is not, and my grounds also I have taken.
the point is with, my lord, with regard to served only. The served, whether it was served or
I am
not.
not denying,
Now, if, my lord, they are not.
but
uh,
no
then-
proper
then
notice
it
has
is a
been served.
different issue, my lord. Whether it was challenged before this honorable court, the
Call
notice
the
was
records,
challenged.
see that,
Yes.
we'll call for the records. Because if the Supreme Court is now saying that you decide on merit, we'll decide on merit then.
I've been given an opportunity, that is my humble submission, because the petitioner's fundamental right, my lord, has been violated.
So see that.
The
those things
opportunity,
we'll
my
call
lord,
for the
is a
records.
serious punishment, my lord.
We'll call for the record, we'll see that.
Because, my lord, that is qualified by the next line of the same, my lord. As such, he had no opportunity to challenge the same within a reasonable time. That's why the notice was not served properly
Call for
at
the
the time,
records
so
for
it is not
examination.
put the opportunity.
Heard Mr. P.C. Dale, learned counsel for the petitioner and so and so for the respondents. Next. Pursuant to order dated 27/2/2026, passed by the Supreme Court of India in petition for special leave to appeal within bracket C, bracket close number 7428 of 2026. Give a dash. Mohammed Manas, M.A.N.N.A.S. Manas Ali, versus Union of India and others. The present review petition has been filed. In view of the directions contained, in view of the observations made in paragraph 3 of this said order, the court is inclined to call for the records of and case number NFT within bracket number 3, bracket close 784/16 within bracket capital D, corresponding to D/case number 995/98 from the disposed of by order dated, by opinion dated 10/5/2018 from the Foreigners Tribunal third, Nagaon. Next paragraph. The registry shall send the requisition to email to the following email address of the learned tribunal. Next paragraph. In the meantime, it is provided that in the event the petitioner, namely so and so, is taken into custody, he shall not be deported out of the country without order of the court. Full stop. The petitioner shall cause production of a certified copy of the order before the Superintendent of Police, within bracket border, bracket closed. Which place?
Nagaon.
Nagaon. To bring the order to
SPB Nagaon.
Huh?
Superintendent Police, Border Nagaon.
Order Nagaon. Next paragraph. List on. Results are on 9th May.
Right.
Results are on
Yes,
9th
yes.
May.
Ninth or fourth?
Fourth,
Fourth May, my lord. Fourth May.
Make it 11 May next year. 11th.
11.
Hearing will not be able to take up, which is the matter?
Item 41 now.
Will not be able to take up. There is a meeting at 4:30.
8 may be